So once you record, excuse me, once you report these judges and magistrate judges with the board that oversees judicial conduct in your state, you have to understand that the intent is not necessarily to have anyone intervene in your case. This is not according to rule of intervention in the civil procedures. That's something else. The judicial board does not have any judicial or legislative power. You're not reporting that judge's conduct to the judicial board with the intent that someone is going to come in and save you. No, that's not what's going on here. The purpose of you doing this is to add to their files. All judges have judge numbers, just like they have attorney numbers and international standard lawyer numbers. Well, as a judge, they also have judge numbers. And part of what you'll be looking at when you look at their economic interest files is sort of linked to that. But that judge number also has a file. And that file is what is kept in determining whether they're going to be reelected or not. And other judges have access to that. Like I've said in the past, these people really don't get along as well as we think they do. Yes, they're all Masons. Yes, they all know each other behind closed doors. Yes, they're all buddies. But nonetheless, they are still competing against one another. And these files and these reports can be used against them by one of them or by one of the people. Because whenever they go into re-election, they are presumed to be constitutional officers. That is the perfect time where you as the people can actually intervene in the elections and use their personal records in their capacity, or shall I say their records of their activities and their misconduct in the capacity of a judge, which shows that they are unfit to be in such a position. With that said, Judicial Inquiry Board, or whatever the equivalence of the Misconduct Board for judges in your state is, they are not here to be this superhero. This is a record that's going to be used to bar that judge from being back in that position, or used to recuse them. The most important part about, once you report the judge to the judiciary board, they'll send you back a letter. The majority of it is really trash, but the most important part is the fact that they're gonna let you know they cannot and will not provide you any other reports that anyone else has made in the past regarding that judge. The presumption is here is to protect the integrity of the one that made that report in the past, and also to protect the integrity of that judge himself, so that there won't be a public outcry. Because most of these acting judges are doing some very wild things while they are on the bench under oath. You know how you have to swear by your documents? I affirm that everything herein is true and correct to the best of my knowledge and belief. That, and then the attorneys have to do the same for it to be admissible as evidence, because it has to be signed as an affidavit. A judge doesn't need that, because a judge is always presumed to be under oath, which is that oath of office to the state law, which is the Constitution, that every other subsequent laws are supposed to be in harmony with. So the moment he or she wears that black robe with a white color peeping out from the inside, all that Masonic stuff, he's presumed to be under oath. Every word that comes out of his mouth must be constitutional. Keep that in mind. And for that same reason, you can recuse them. And you can use this as an evidence of you doing your due diligence in good faith when you do end up suing them in their personal capacity. Believe it or not, things like these are really part of the exhausting administrative process. Since yes, we all know it's an administrative court, and yes, we all know this is an administrative agency. This is part of you exhausting your administrative remedies. And what you really need is for that case to be dismissed or be ruled in your favor. And oftentimes when you do this, you will see a drastic change in the demeanor of that judge. Different types of personalities exist. Some of them are just blatantly disrespectful. Some of them are calm while they screw you over. Some of them try to play the role of being the good guy and say, "Oh, I'm sorry, sir. Excuse me, sir. This, that." But still, they're all screwing you over. Whatever personality type, whatever mask they choose to put on, they all have one thing in common, and that's the fact that they're liable to that Constitution. Do this, and this is part of exhausting administrative remedies in the public. And you can bring this as admissible evidence of you exhausting your remedies, and that is administrative court, before you begin to go after them personally. The most important part of the letter they will let you know is this. It is important for you to note that pursuant to Illinois Constitution, and they know what's up. They know what's up. And the board's rule of procedure. The board is prohibited from sharing with you or anyone outside of our agency the details of any investigation or action taken in lieu of or prior to filing a complaint with the Illinois Courts Commission. Only those documents filed with the Commission during the prosecution of the matter becomes public. And in anything that they engage in terms of investigation while this is going on, where they take it on their home to prosecute it because they've finally found an opportunity to beef with whoever it is that you are reporting, or if somebody else had prior, claims filed against the same man or woman, according to the Constitution, rights and obligation of contract and privacy, and their own private proceeding of how they administer these entities, agencies that judge is tied to. According to those, they are prohibited from sharing anyone information that leads to the investigation of whoever it is that you're dealing with. So it is incumbent upon you to share this type of information with other people so that when you do have the same magistrate or acting judge screwing around and you do go through this exhaustion, you now all have records that you can use as paper trail that have something in common. That is how you take over the courts. That's part of how you slowly begin to take things back into your own hands. Exhaust your remedies and use the records against them. Because the only other type of people that have the results of these proceedings and the paper trail of them exhausting these administrative remedies are the ones that did it. So show other people and have them do this properly. And then use the final determination to your benefit. Now, oftentimes before the final determination, that judge will dismiss the case if you're the defendant, or they will recuse themselves. Personally, I don't like recusing judges. I like making them do their job. You're there for a reason. You're already here. No need for us to start this crap over. You and I are here. We're going for a ride. That's simple. It's not personal. It's just business. Do your job so that you can stop seeing my ugly face, so that you can stop hearing my annoying voice, so that I cease to become the liability in your their business and personal affairs. It's really that simple. And within those Supreme Court rules are lists of regulations of judges' requirement of impartiality. Now, this is not necessary, but it's just merely an affirmation of the Constitution. And they call it canons. Canons of Code of Judicial Conduct. You use this as evidence in judicial complaints and in rebutting their orders if you smell the slightest hint of conflict of interest or anything else within this list that judge, acting judge, qualifies for. So in short, a judge should be faithful to the law. What law? The Constitution. And maintain professional competence. A judge should be unswayed by partisan interest, aka other attorneys. This is really impossible for every judge if you can prove that they are lawyers. And the lawyer on behalf of the state of or whoever is bringing a claim against you, if you can prove and show their lawyer credential, they are automatically disqualified by virtue of this. The judge shall not initiate, permit, or consider ex parte communications, and they do it without you. A judge shall perform judicial duties without bias or prejudice. Conflict of interest with those attorneys, same thing as being biased and prejudice. And trust me, acting judges are very, very comfortable when it comes to just imposing attorneys and public defender and people. In fact, it's their mode of operation. It's as if they take joy in it. And you should too. You really should. The moment you hear any judge trying to impose an attorney on you and you gave them verbal judicial notice the first time, second time, and the third time, joy should be rushing through you. Begin to rebut and object to those orders. And take these steps. Just as they have mode of operations, if-then circumstances on their end, you should have if-then circumstance on your end. They do this, it's very simple. You know how you respond. They impose an attorney on you, whip out the canons, rebut and object to their orders, create writ of error, put in admissible evidence to back those things up. Remember, evidence are necessary. Then take all those filed records, use it as exhibits with the Judicial Conduct Report. The judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice, including but not limited to the bias or prejudice based upon race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status, and shall not permit staff, court officials, and others subject to the judge's directions and control to do so. There's a lot more. Another very interesting part. You can actually view most judges are required to keep records of their financial interests. And you'll be surprised what you will find. And that record is public. You can actually view it. You can actually get access to it. In Illinois, it's in Rule 68 that the Supreme Court orders. A judge shall file annually with the clerk of the Illinois Supreme Court a verified witness statement of economic interests and relationship of the judge and members of the judge's immediate family. So if you're looking to sue people in private capacity and you want to create your own little dossier and cross-reference information, here's another way you can get that, but that's a whole nother subject matter. And they call it the statement. So just call up the clerk of the Supreme Court and let them know you intend to inspect a copy of so-and-so judge's statement according to Rule 68. They'll give you a time to come in and come inspect it. They'll be very hesitant to send copies to you, but it might be easier to just go in and inspect it. Use common sense in how to follow up on the rest. As statements are filed in the clerk's office, the clerk shall cause the fact of the filing to be indicated on an alphabetical listing of judges who are required to file such statement. Blank statement forms shall be furnished to the clerk by the Director of the Administrative Office of Illinois Courts. Any person who files or has filed a statement under this rule shall receive from the clerk a receipt. Any person who files or has filed a statement, aka that acting judge trying to impose an attorney on you, showing bias and partisan interests, and is not impartial, shall receive from the clerk a receipt indicating that the person has filed such statement and the date of such filing. This receipt, the clerk keeps a copy of it. Get a copy of it also. Clerk of the Superior Court now. This is Illinois. I don't know how it is in other states. So find a corresponding aspect of this in your state. Get the statement. Get the receipt. All statements filed under this rule shall be available for examination by the public. All statements filed under this rule shall be available for examination by the public during business hours in the clerk's office in Springfield or in the satellite office of the clerk in Chicago. Original copies will be maintained only in Springfield, but requests for examination submitted in Chicago will be satisfied promptly. Satellite office. Each person requesting examination of a statement or portion thereof must first fill out a form prepared by the director specifying the statement requested, identifying the examiner by name, occupation, address, and telephone number, and listing the date of the request and the reason for such request. The director shall supply such forms to the clerk and replenish such forms upon request. The director shall supply such forms to the clerk and replenish such forms upon request. So the party that you direct this request to, the statement and the receipt, is the Director of the Administrative Office of Illinois Courts. Copies of statements or portion of statements will be supplied to persons ordering them upon payment of such reasonable fee per page as is required by the clerk. Clerk is just the keeper of records in this situation. Director being the medium that you go through to access records of that acting judge, the financial statement, written statement, and the receipt. Payment may be made by check or money order, blah, blah, blah. Clerk shall promptly notify each judge. This is the interesting part. They notify them that somebody's speaking into their dress. Each judge required to file a statement under this rule of each instance of an examination of the statement by sending the judge a copy of the identification form filled out by the person examining the statement. It goes both ways. Want to view their files, they get to see whatever information that you put down. Whatever information that you put down. Whatever information that you put down. The contents of the statements required by this rule shall be specified by administrative orders of this court. You'll be surprised what you will find in these files. Some judges just have casual stuff in there regarding their economic interests. Others, you will find that they actually own lawyer firms. Yes, some of these judges own lawyer firms. And guess what? Those lawyer firms hire some of those attorneys that work in those courtrooms. Those law clerks under each judges. You'll be surprised once you start cross-referencing information. You'll be very shocked to find out very interesting things about bias, prejudice, economic and pecuniary interests. View these files, put it to use, and add it onto the record. If you've ever wondered how you can make those court proceedings and turn it into your court, this is one of the ways that you do it.